your damaged goods. This statement from the CEO of Betancourt Aviation explains this entire case. They thought that Ms. Parker's injury made her damaged goods. So after 11 years of dedication to Betancourt Aviation, Ms. Parker, she was injured. And that is when everything changed. For the first time ever, they took away essentially all of her job duties. And then the defendant, Robin Alley, ridiculed Ms. Parker, harassed her, and abused her. And then they fired her. Now, what happened to Ms. Parker is not right. Not only is it not right, but it's illegal. I'm going to take the time to explain to you why Betancourt's conduct was illegal. But before I do, I want to talk to you a bit about what it means to be an at-will employee. When you agree to be an at-will employee, you take on a certain amount of risk. For example, your employer can fire you for being late to work a few times, for missing a company picnic. Well, it might sound a bit strange, but when you're at will, this is exactly what an employer can do. Quite literally, they can do almost anything. But the one thing that they cannot do is fire you for an illegal reason. Firing someone because they took time off to go get treatment to heal for an injury is illegal. And the law that does this is called the Family and Medical Leave Act. It protects you when you have to take time off of work to go get treatment for an injury, and even if you have to take time off to go to physical therapy during the workday. And it protects you because it's unfair to punish someone for having a serious injury. Injuries are often out of our control. Our society recognizes this and the need to protect people who find themselves in this vulnerable situation. That's why we have these laws. So let's take a closer look at one of the laws that we have in today's case, our claim for FMLA interference. I'm going to walk through the elements here briefly. The first is that Ms. Parker had a serious health condition. We know Ms. Parker was injured. It was serious. This is not in dispute between the parties. The second, that Ms. Parker sought leave on an intermittent basis. We know that Ms. Parker took FMLA leave to go to physical therapy 3 to 4 times during the work week. Again, not in dispute here. Third, that Betancourt granted Ms. Parker's request for intermittent FMLA leave. Everyone here agrees that Betancourt allowed Ms. Parker to go to physical therapy during work. Again, not in dispute here. All that's disputed is this, that Betancourt interfered with, restrained, or denied Ms. Parker's right to take FMLA leave by terminating her. We have to prove to you here today that Ms. Parker was fired for using the Family and Medical Leave Act. In order to show you how we've proven this, I want to take you back to a few key dates that you learned about in today's case. You learned that Ms. Parker, she was hired way back in 2002. And before her injury, things were good. She and the defendant, Robin Alley, were friends. She had a job. She had things to do. There were one of these critical comments coming from the defendant, Robin Alley. But as you know, Ms. Parker, she was injured on July 25th of 2013. And that is when everything changed. Let's take a closer look at what that really meant for Ms. Parker. When she returned to work, she started to go to physical therapy about 3 to 4 times a week during the workday. Now, before she had nerve damage and had to go to physical therapy, you learned that she and the defendant, Robin Alley, they roughhoused. They punched each other. They hit each other. No one denies that. But after this injury, it had to stop. And it did stop for Ms. Parker. It all became one-sided. Her arm was in a sling. She was in obvious pain. That's why she asked the defendant, Alley, not to hit her. But she kept getting hit. Now, why would the defendant, Robin Alley, continue to hit Ms. Parker after being told explicitly 10 to 11 times, do not hit me anymore? Why would she continue to hit Ms. Parker? It might not make sense at first, but when you take a look at their relationship, it does. You learn that before this injury, the relationship between Ms. Parker and the defendant, Robin Alley, was based entirely on fun. But the injury threw a wrench into that fun. It was a change in their already unique relationship, a change that the defendant, Robin Alley, just could not accept. Ms. Parker, she couldn't go on these 3 to 4 hour extended lunches during the workday. She couldn't play video games like she used to. And the defendant, Robin Alley, didn't have her drinking buddy anymore. And when you look at what the defendant said, this is exactly what was going on here. The defendant said things to Ms. Parker like, "You're no fun anymore. I can't ask you to do anything. You're no good to me anymore. You're damaged goods." It wasn't just one comment, it wasn't just two, it was all of the time. Multiple comments, 2 to 3 times a day. And when did these comments start to come up? Right around the time Ms. Parker started to go to physical therapy. Now the hitting and these degrading comments, they aren't the only things that changed after Ms. Parker's injury. No, Betancourt Aviation took away essentially all of Ms. Parker's official job duties as plant manager. Now you would expect that when an injured employee comes back to work and is ready to tough it out and ready to do what she needed to do, you would expect that her employer would welcome her. What do instead? They take away all of her job duties and have her run personal errands for the 2 owners of the company. Now the hitting, these degrading comments, and the job duties all changing are evidence of interference, which led directly to Ms. Parker's termination. And we now know this because we know that the defendant, Robin Alley, was really the one pulling the strings on this termination. You heard me cross-examine the defendant, Robin Alley, earlier today. She told you she was not involved in the decision to fire Ms. Parker, but she was. Right after the October 10th incident, the defendant, Robin Alley, sent Ms. Parker home. The defendant cut off Ms. Parker's company cell phone, and the defendant, Robin Alley, changed the locks on Ms. Parker's office door. The next day, the defendant, Robin Alley, had a meeting with Ms. Parker and another manager. Right after this meeting, the defendant, Robin Alley, met with the president of the company alone, the supposed person who made the decision on this firing. And then the very next day, the defendant, Robin Alley, is yet again in another meeting with Ms. Parker and the president of the company. The meeting where Ms. Parker was fired. And in that meeting, guess who informed Ms. Parker that her personal belongings had already been removed from her office and sent to her car? The defendant, Robin Alley. The defendant wants you to believe that as CEO of Betancourt Aviation, she had no say in her best friend's firing, when the defendant was the one who made all the decisions. The defendant was the one who was at all of the meetings. The defendant was the one who was really pulling the strings on this termination. This ties everything that we've been hearing about today together. Who made these degrading comments? The defendant, Robin Alley. Who made Ms. Parker run personal errands for them? The defendant. And who continued to hit Ms. Parker despite being told not to? The defendant, Robin Alley. Why? because everything changed after the injury. It proves to you the real reason that Betancourt fired Ms. Parker. They fired her for using the Family and Medical Leave Act. Now I want to take a look at our second claim in today's case for retaliatory discharge. And just like it's illegal to fire someone for taking time off to go get treatment, to heal for an injury, it's also illegal to fire someone for engaging in what we call protected activities. The protected activities in this case are filing a workers' compensation claim or filing a police report. These are protected activities because we want to encourage people to report illegal conduct and criminal activity. And we want to encourage people to file workers' compensation claims when they're injured at work. So let's take a closer look at the elements for this claim. The first is that Ms. Parker engaged in a protected activity by filing a workers' compensation claim or filing a police report. Ms. Parker, she filed a workers' compensation claim and she filed a police report. This is not in dispute between the parties. Second, that Betancourt discharged Ms. Parker from her employment. Everyone agrees that Ms. Parker was fired on October 12th. Again, not in dispute here. Third, that Ms. Parker's discharge was causally related to her protected activity. In order to prove to you how we've proven this claim, I'm going to take you back to our timeline here. You learned that on July 27th of 2013, Ms. Parker, she filed a workers' compensation claim. Betancourt knew about this workers' compensation claim, and Ms. Parker told you herself what happens at Betancourt when people file workers' compensation claims. The question is always raised. How can we get rid of her? You also learned that Ms. Parker, she filed a police report against the defendant, Robin Alley. Ms. Parker told the president of the company about this report, and the president's response, "Your arm sure has caused a lot of trouble." Let me repeat that for you. The president of the company, "Your arm sure has caused a lot of trouble." Ms. Parker informed the defendant, Robin Alley, about the police report, and the very next day, she's fired. This timing, members of the jury, and the way that Betancourt treats people who file workers' compensation claims proves to you that Ms. Parker was fired in retaliation for both of her protected activities. Now, I wish I could just stop right there. We have to take a look at the story of the defendants want you to believe. They've claimed, not only to Ms. Parker, but to this court, and you will see later on today in the jury instructions, that they fired Ms. Parker because of her refusal to apologize for her conduct on October 10th and her refusal to explain her actions. Let's take a look at this reason, see if it really makes sense. Claim they wanted an explanation, but they had one. The president of the company told you that she knew Ms. Parker was upset about her boss hitting her. And in fact, Ms. Parker was so upset that not only did she tell the defendant, Robin Alley, not to hit her, but for the first time ever, she went to the president of the company for help. This was the October 7th incident that you heard about here today, where the defendant, Robin Alley, hit Ms. Parker and she fell to her knees, almost in tears. This was all the explanation that they needed, but they had more. The day before Ms. Parker was fired, the president of the company told you that she knew Ms. Parker was frustrated. And Ms. Parker was frustrated because her boss continued to hit her, despite being told not to, over and over again. They were well aware of this issue. They had the explanation that they claimed they were looking for. And if that wasn't even enough, they made it essentially impossible for Ms. Parker to explain herself or apologize during the October 12th meeting. So the defendants claimed that October 12th was the day they were going to sit Ms. Parker down, see if she was willing to apologize or explain herself for her actions on October 12th. Up until this point, according to their story, she was not fired. It all came down to if an apology or an explanation would come out. But what do? Does the defendant, Robin Alley, apologize for hitting Ms. Parker on October 10th? The defendants explain to Ms. Parker exactly what they're looking for from her. No. They put her in a room with two people. The first is the one who's hitting her and ridiculing her. The second is the person who ignored her complaints. And they start this meeting off by accusing her of falsifying some unrelated document. You cannot treat people this way and expect an apology. The truth is, they were never looking for an apology. They were looking for an excuse to get rid of Ms. Parker. And so they did this investigation. An investigation that lasted a grand total of 40 minutes. That's what Ms. Parker's 11 years at Betancourt was worth to the defendants. 40 minutes. An investigation that came out to this half-page report and left out all of the important information. You heard my co-counsel, Ms. Haney, cross-examine the president of the company about this investigation. And the president told you that she did not want to interview any other potential witnesses. She didn't read any of the documents that were submitted to her about the incident. In fact, the president claimed to you that she wanted an explanation when she makes a conscious decision not to read the statement from Ms. Parker about the incident, which was the one document that could have given her the explanation she claims she was looking for. And worst of all, the focus of this investigation was to see whether Ms. Parker should be fired, when the defendant, Robin Alley, was the one who repeatedly hit Ms. Parker. Their investigation was a cover-up. It was a cover-up for the real reason that they fired Ms. Parker, her injury and everything that flowed from it. The law requires you to look at their reason and see if it was merely a cover-up for retaliation. And again, the real reason that they fired Ms. Parker was for her injury and everything that resulted afterwards. Their investigation was a cover-up. And this is especially true when they're claiming that this disciplinary policy had anything to do with Ms. Parker's firing. They don't care about this policy. You learned that the defendant, Robin Alley, had a gun and knives on company premises. Knives that were used along my client's arm and neck, both of which are clear violations of this policy, which they never cared about for 11 years. It only became relevant when they needed an excuse to get rid of Ms. Parker, when they needed an excuse to get rid of damaged goods. But members of the jury, Ms. Parker is not damaged goods. She was a dedicated employee for 11 years. She is a mother with a family, and what was supposed to be a month or two of healing and treatment turned into an absolute nightmare. She was ridiculed, harassed, and abused. And when she finally stood up for herself, they fired her. Hold them accountable. Do not let them get rid of what they believed to be damaged goods. An injured employee. Find them liable for both claims. Thank you.